So let's start with the presenter of today, the speaker of today, and I'm joined with my team, but let me start by introducing myself. I'm Linda Nseke. I'm the Director for Technology and Venture Initiative and Engagement at CTL. And Lisa, do you want to introduce yourself?
Hi, good afternoon. I'm Lisa Plekanica. I'm the Senior Managing Director for the Center for Technology Licensing at the Cornell Medicine Campus, which is part of a larger group called Enterprise Innovation, serving the innovation and entrepreneurship needs of Cornell Medicine researchers.
Bill?
I'm Bill Pegg, Director of Intellectual Property.
Martin?
Yes, hi and welcome everyone. My name is Martin Teschel. I'm Director for Business Development and Licensing on the Ithaca campus.
Perfect, thank you. So what we'll be talking about today, it's our first one, and we want to make sure that you understand the basic of technology commercialization, particularly because we are doing so many different activities related to that topics. So we'll start with first, what CTL does. CTL is the Center for Technology Licensing, what we do, and what's the different resources that we'll provide to you as an innovator, inventor at Cornell, but also as student or even as entrepreneur. And particularly, we want to put a focus on innovator at Cornell across the different campuses. And we'll be talking also about how the university tech transfer, what it is, but also our Bayh-Dole Act is allowing us to do our job. And we'll talk about the IP primer, and then we'll finish by talking about evaluating and also commercialization innovation. Next slide. So we are part of Cornell Research, and it's a big enterprise. You see the number, it's 1.6 billion, it's quite huge. And it's across 5 different campuses in Ithaca, Geneva Tech, Cornell Tech, Cornell, in New York City, and also in Qatar. Next slide, please. And mainly, the result of that research is disclosure, innovation. And you can see how it's impact here, the metrics that CTL care about. Because basically CTL is a commercialization arm of Cornell University. We manage all the IP across the 5 campuses. And our mission is to catalyze the technology commercialization, to develop new products, new services, but also to promote new technology ventures. And the numbers that we care about, among other numbers, are the number of new disclosure that you sent to us. So last fiscal year 2025, we received 293 new invention disclosure from you. And also the BD and licensing team, they assess the technology, and also the IP team, they protect the technology. So we had 96 issue patent in the US. We had 138 US provisional patent application. The BD team, they did some marketing, and Martin will talk later about this, and they license, and we obtained 93 license and option. And lastly, we secure the creation of 15 Cornell startup. Next slide. So let's talk about the 4 pillars that is important here. First, the gap funding. So the goal with the gap funding is to accelerate technology, support new venture creation, and also to help train a new entrepreneur, scientific that we want to become entrepreneur. So next is the technology licensing and IP. We, as I mentioned, CTL manage the IP. We support the inventor, and also the BD teams are doing marketing and trying to find licensee for our innovation. Then we have the technology startup, because we want to support new venture development and creation. So we have a tool like the fast track to enable that, to help. It's one way to license technology. We have also a lot of initiatives to support startup connection with an investor. And we have also a full ecosystem that we leverage, we partner with to enable that. And lastly, the education and outreach. Like today, we are trying to create a learning ecosystem where we are talking about what we do at CTL, but also we are inviting speakers externally to talk more about what is commercialization, how we can improve together and do more activity and create more activity. Next slide. So you can see the details. I won't go through the details here, but it will be for you to review. You can see we have a lot of activity, and particularly through the Ignite program that I will talk a little bit later, where we had 7 startups that we have funded. But it's some data that I will let you dig into later on. Next slide. Here, through this slide, we want to show the impact of all those activity that has been developed over the year and implemented over the year. You can see here the creation of new startup based on the IP coming from Cornell has been increasing. So, and this year alone, last fiscal year alone, we had 15 startups created and 118 active startup total. And those 118 startup has raised 461 million in equity, note, and also grants, which is quite impressive. Next slide. So who are our stakeholders? You, Cornell inventor and innovator. So we provide a list of support and across the different spectrum of the different process and pathway of commercialization. We have office hour, and Martin will talk about that. We have different recognition award and educational programming, as I mentioned. But let's go to the next CTL stakeholder. We have, of course, the entrepreneur and startup, because we want to emulate this ecosystem, entrepreneurial ecosystem. So we have a list of programs for them that I will let you review because we'll share the slide later. Next. So the student, of course, we want to support the student, and we have programs to support that. It has been put on pause, but we hopefully will continue in the coming fiscal year. Next. Last but not the least, the corporate partner and the investor. We are creating different events to enable the connection between our innovator, also the industry partner, but also the investor, so we can push the commercialization into the market of our innovations. Next slide. First lab to market, lab to impact, I mentioned, it's educational programming, it's a learning opportunity to create this engagement between our office, but also you, so we can engage more and address the different innovation, different ecosystem member, but also to provide more speaking and engagement opportunity. So we have 4 main topics here: the IP, commercialization and venture. We have also healthcare, but also we have social science. Next. One program that I would like to highlight, because you can be engaged to that program. So it's a SIVA advisor. It's an initiative that enables seasoned advisor to join. It's an exclusive group. To join that group, we have, as of today, 165 members, and they provide feedback to our inventor and innovator. And every quarter, because we have a quarterly roundtable, we select 3 innovators that present to them. And this enables, it's an opportunity for you as an innovator and inventor to receive feedback from investor, but also industry partner. So it can, your technology can be discussed in terms of strategy, direction, and also it can be grounded into the market. So you can be the next presenter, reach out to any of our team members for that. Next. And so lastly, the Ignite Cornell Lab to Impact. So why we have created this program and the GAP funding program, because we have 2, Ignite, but also Catalyst Fund. Why we have created this program? Because at some point we receive a lot of invention disclosure, the IP team work on protecting them, and at some point when the BD team, they do marketing, a lot of the feedback is too early. So we were able to create that program to be able to de-risk the technology, move it further so it can be more attractive to external partners such as the industry, but also entrepreneurs who want to create startup with us. Next slide. Under the Ignite program particularly, we have 3 main program. And we call that Ignite Gap Funding Program Series. It's a series of programs because we have 3 here. So one is innovation acceleration. So we have, it's a grant to innovator in a lab, and it's up to 50K. And we have also Ignite Fellow for New Venture. Basically, it's an accelerator of 12 months where we recruit as Cornell employee. It can be a recently graduated PhD or MS holder, and they can receive up to $120,000 for developing a technology in partnership with one of our main PI and faculty inventor. It's by the way, it's a annual cycle, so feel free to look in November because we'll open the next application in November. And for Ignite Innovation Acceleration, the next cycle is starting end of this month. And the last one, Ignite Startup Project, it's a target audience here, our startup already created, already operational, and they can receive up to $75,000 to be able to scale their technology and grow their business. Next slide. We have also the Catalyst Fund at Cornell that has been implemented this year. If you have any additional questions, feel free to reach out to the team at and particularly Lisa here. But let me quickly go through the 3 different programs under the Catalyst Fund. You have the Proto Award that provides up to $50,000. You have the Validation Award that provides up to $200,000, which is quite significant. And you have the Breakout Award that provides up to $400,000. And all those programs to differentiate from Ignite are for the lab, are for the faculty that are in the lab. Next slide. So we are able to create all those initiatives and programs because we are supported by our leadership, Alice and Lisa. Next. And of course, by a different team. We have the Technology and Venture Initiative and Engagement. It's my team, and I have 2 great team members, Chris and Aaron, to support all the programming related to the outreach, but also Ignite. Next. The IP member, and Bill will present what they do later, but we have the patent management and the Bill team, but also the IP services, and you may have engaged a lot with them. Next. And the BD team, we have the BD team in Ithaca. You have Martin, who's leading that team. And of course, they are working with you on the disclosure, but also trying to find potential licensing and marketing all those technology. Next. And I will let Lisa now talk particularly about the WILD team and about the WILD Enterprise Innovation Structure. Lisa?
Great. Thank you, Linda. Good afternoon again, Lisa Placanica. So we have a full team down in New York City at the Cornell Medicine campus, focusing on the healthcare innovations coming out of research at the Cornell Medicine campus here in New York City, as well as our sister institution in Doha, Qatar. We're part of a group called Enterprise Innovation, which is really an umbrella organization created a few years ago. That was a consolidation and reorganization of different teams and groups that touched upon various aspects of innovation and entrepreneurship into really a single organization working together and strategically. So CTL and the team at CTL at the Cornell Medicine campus were the core business development function of that group. And we're really looking to nurture, protect, and source innovation and research being developed here at Cornell through research collaborations, alliances, and licenses with external parties and partners, whether that's new co-formation and working with investors and funders, or whether that's with existing companies. We have our BioVenture eLab is our core resource for those faculty and researchers that are interested in entrepreneurship, with the aim of really fostering an entrepreneurial ecosystem and culture and providing a lot of resources and training in entrepreneurship to our research base. As Linda mentioned, we also manage the Enterprise Innovation Catalyst Fund. This used to be known as the Daedalus Fund for Innovation. And this is our key resource for gap funding measures to help advance technologies to the point that they can be partnered. Next slide, please. So this is just some of our team members. Every department and institute at Cornell has a dedicated business development point person. You can find them on our website or reach out to me and we can certainly connect you. Next slide. And next slide. In addition to working closely with our colleagues at CTL and Ithaca, we also have a suite of programming and resources that are really focused on healthcare at the medical campus that we run. Many of these are organized and promoted by the BioVenture eLab. Some are focused of the Center for Technology Licensing at Cornell Medicine campus, and they're really healthcare focused. They're open to anyone in the Cornell ecosystem. And many of our programming we offer virtually through webinars, and we also make an effort to record our programming and put it on our website in our learning library so that you can kind of learn at your own pace. We have our own events calendar, which also pulls through other programming throughout the Cornell ecosystem that might be of interest. Next slide. Next slide, Chris. A special showcase of one of the courses we run. So for Wall Cornell Medicine graduate students, we do have a credit-bearing course that's available through the pharmacology department that we run in the spring that is focused at providing kind of a hands-on training in the management of academic innovations, covering intellectual property, technology evaluation, and kind of marketing commercialization activity using real-world Wall Cornell innovations as case study and course material. So if this is of interest to you, I suggest you check it out and advertise it also to your students. Not only does it help them understand potential alternative career paths beyond the bench, it also helps them to look at their science in a different light. And that's also a useful outcome of this. Next slide. Next slide. So, what we're talking about here, we've talked a lot about intellectual property, we've talked a lot about commercialization, and we're going to kind of get a little bit into the why here. So all intellectual property that's developed by Cornell researchers or using funds, facilities, of resources of the institution is owned by the institution under the IP policy. This is policy 1.5. And the university takes on sort of the financial risk investing in this early stage innovation and intellectual property on behalf of the university and the researchers. And this is consistent with how other universities also manage their intellectual property. Next slide. And the reason for this is really something called the Bayh-Dole Act that was passed in 1980, which seems like a lifetime ago, and was deemed possibly the most inspired piece of legislation to be enacted in America over the half-past century. And what this piece of legislation did is transferred the ownership of intellectual property developed from federally funded research from the US government to the academic institution. Prior to the passage of the Bayh-Dole Act, less than, the government owned maybe 30,000 plus patents, issued US patents that arose from federally funded research, but less than 5% of those patents were licensed or transferred to commercial entities who were really doing anything with the intellectual property. And so there was this realization that this vast, intellectual output of federally funded research dollars was just laying fallow. Nothing was happening with it. Nobody was benefiting from it. And on the right-hand side, we see a kind of a graphic from Autumn, which really demonstrates that once the universities were put in the position and the obligation to be good stewards of the intellectual property that arose from federally funded research, there was tremendous impact on kind of economic development measures, such as number of jobs created, number of, increase in the gross domestic product and the number of patents that were issued. But really what's very impactful is sort of, the bottom line is you really see a lot, number of startups created based on intellectual property from universities that rose from federally funded research. And, what's a particularly impactful number to me is the kind of bottom right. So 200 drugs and vaccines that are on the market today that kind of can trace their history and their lineage to university research that was funded by federal dollars that was then partnered with a commercial entity who brought that product to market. So really impactful. And so next slide. And that's sort of what we see is when we talk about lab to impact, that's really what we're talking about is acting as that bridge and that intermediate between the research that's happening at the university and the commercial marketplace who's going to kind of translate that research into tangible products and services that really benefit society. And here you can see just a few of the products that are on the market that have their roots and their origin story in Cornell research. And it really covers kind of every walk of life. So obviously, as a land-grant school of New York and strong agricultural school, a lot of our intellectual property is within sort of the ag space. So apples and grapes and potatoes, peppers, you name it. Cornell has touched it, and these are kind of products that are benefiting kind of the food resource and security of the country. Medical devices, genomic sequencing innovation, therapeutics, diagnostics, really kind of any product you can think about. We're interested in working with you to see how we can move it from the lab here to the marketplace, right? And so that's really sort of that tangible realization of impact from the research. Next slide. Again, I mentioned the Bayh-Dole Act previously. It did not come without strings, right? So there is a pact we have with the US government in exchange for the right to take ownership of the intellectual property. We do have an obligation to try to translate that into a product and commercialize it. We have a preference for working with US-based companies, a preference for small businesses over large, manufacturing requirements in the US. And of note, a portion of the money that comes to the university from successful commercialization is required to be shared with the inventors and the contributors of that intellectual property as personal income. So in addition to the societal impact and benefit, which really drives a lot of what we do, there is also financial benefit to the inventors working with us. We have to report the invention to the government. So it's very important when you're working with a CTL to let us know if you had federally funded grants that gave rise to that intellectual property. And the government reserves certain rights in the invention. They have a non-exclusive right, and they have the right to, quote, march in the cases of kind of public health or public crisis needs. So it's the symbiotic relationship where the government has rights in the inventions that are made, but the university is the steward of ensuring that it's translated into products that benefit the US taxpayer. Next slide. With that, I will pass it off to my colleague, Bill Pegg.
Thank you, Lisa. Okay, next slide. So I'm just going to touch on the Bayh-Dole Act a little bit more because it's very important. So what is on the screen now kind of mirrors what you'll see in Policy 1.5 on intellectual property, specifically patents. So Cornell is under an obligation to require its employees to disclose promptly in writing each subject invention made under contract, to assign to Cornell the entire right, title, and interest, and to execute all papers necessary to enable Cornell to file patent applications. So the government is requiring Cornell to perfect its rights so that we are in turn perfecting the government's rights. Next slide, please. And the government takes preservation of its ownership rights, or at least its potential rights, very seriously, in addition to putting the obligation on Cornell or the contractor to try to commercialize it for the benefit of society. So as an example, I pulled some language from the NIH grants policy statement, and you'll see similar requirements in other agencies, where they basically say that the funding recipient must comply with the Bayh-Dole statute and implementing regulations, and failure to comply with all of the regulations can result in the loss of patent rights or the suspension, termination, or withholding of funding. And I won't go into the enforcement actions and everything else. The bottom line is there are strings attached to the funding, and we have to make sure that we comply. Next slide, please. The number one way that we are able to comply is if when the researchers disclose the invention, they seriously think about what funding might have been used and let CTL know in the invention disclosure statement that there was government funding. If we find out about it significantly after the invention disclosure is submitted, it could be too late, and it could cast a cloud on the title of the invention and could lead to problems. So early and accurate disclosure is very important. Next slide. So what is intellectual property? Well, it's pretty much everything. It covers therapeutics, medical devices, digital health, data, high tech, pretty much everything that you can imagine finds a place somewhere in the spectrum of IP. Next slide, please. This is just showing patents, trademarks, copyrights, and trade secrets are all different aspects of intellectual property. And statutorily, they all cover different aspects of protectable IP. Next slide. So patents are covered under Cornell Policy 1.5, and they provide a legal monopoly on a particular technology in exchange for the disclosure of that technology to the public. So it gives a right to exclude others from practicing the invention once it issues. It's only enforceable after it issues. And it's valid for 20 years from the effective filing date. So the longer that it is pending in the patent office, the shorter the actual term that you would enjoy. And one thing we'll touch on a little bit later, inventorship is a legally defined concept, and it's distinct from authorship. Next slide, please. Copyrights are covered in Cornell Policy 4.15. It protects original works of authorship fixed in a tangible medium of expression. So for software in particular, which is a lot of what we deal with in CTL, as far as copyrights, software is protected as a literary work. It does not protect the functional aspects of a computer program. So it is merely the expression of letters, numbers, characters on some fixed medium, magnetic recording medium, etc. Data itself is not copyrightable, but a creative arrangement, annotation, or selection of data can be protected by copyright. Next slide, please. Trademarks are covered in Cornell Policy 4.10. Can be any word, phrase, symbol, design, combination that identifies an origin for a particular good or service. And that's a pretty important aspect of trademarks. It's identifying the origin of the good or service, not necessarily the specific good or service itself. There are character-only trademarks, which is just a word mark. So you have a word, and typically, as you would expect, it would be something distinctive because it has to be unique. Then there are also special form or logo trademarks, as you could see with the McDonald's arches or the Nike swoosh. So they're distinctive, stylized. They can be black and white or in color. Next slide, please. So there are statutory requirements of patentability. I'm not going to get into all of the details, but in general, Section 101 is 35 USC 101. So Section 101 covers what can and can't be patented. Section 102 deals with novelty. So basically, an invention has to be different than everything that came before. Obviousness, Section 103. The invention has to be not obvious in view of the prior art. And with Section 102, generally it's a single reference. Some publication identically discloses what is now being claimed. With Section 103 and obviousness, the patent offices can combine different aspects of multiple pieces of prior art and say that the combination of all of those different elements would render what is now being claimed obvious. And that's something that we have to argue in the patent office as to why it would not be obvious. Section 112 has to do with what we disclose in the applications. And that gets back to the issuance of a patent and the monopoly. It's sort of a quid pro quo of the disclosure to the public. If it is disclosed sufficiently, then it enables the sort of the issuance of a patent application, provided the other requirements are satisfied. So it requires a written description of the invention, details as to how to make and use the invention. So it has to enable other people in the art to actually be able to replicate it. And the best mode of the invention. The government does not want inventors to hide the ball, to keep the best embodiments of it secret and disclose lesser embodiments and still get the benefit of a patent without disclosing what they know to be a better way of doing it. Next slide. So a couple of different types of patents that you'll hear about. One is a provisional patent application. It's an informal application, can be filed relatively quickly. It's not examined. Nobody looks at it in the patent office. It's simply a placeholder for any subject matter that is disclosed and enabled in the provisional application. So if the disclosure doesn't tell a person skilled in the art how to make or use the invention, the value of the filing is questionable. It may not give a priority date for a later filing, and it automatically expires after 1 year. So it's a 1-year placeholder. A non-provisional or PCT, Patent Cooperation Treaty application, those are the formal applications. If a provisional application is filed, the non-provisional or PCT has to be filed within 1 year before the provisional expires. And the utility application has to fully describe the invention in sufficient detail to enable a person of ordinary skill in art to make and use the invention. So again, the written description has to be there. There has to be enough data, enough information that people in the art, in the field, are able to look at it and say, oh, okay, I know how to take this information and do something with it. And it's not something that can be supplemented after filing. So everything possible needs to be included when it is filed. Next slide. So here's a patent life cycle, and this is just sort of a generic illustration of the fact that it's a very long process. So on the left side, it starts with conception of the idea, the submission of an invention disclosure form to CTL. Often we'll file and we'll do a prior art search to see if there is anything like it out there. Make sure that it's at least novel. And then we go through preparation of a patent application. Usually we'll file a provisional patent application to buy some time, additional research, make a decision later about whether or not to file a PCT or non-provisional patent application. Once that's done, it starts a period of patent prosecution that can take, on the slide, it says 2 to 5 years. It could take much longer than that. But there's a lot of back and forth between CTL, the inventors, the patent office, to try to overcome whatever rejections there are, such as obviousness, lack of novelty, et cetera. Once a patent issues, which could be 3, 4, 5, 6, 7 years after filing, then we would have to pay issue fees. After that, the statute requires that we pay ongoing maintenance fees. So it's kind of pressure on the patentee to continue paying money or let it go where it's dedicated to the public, and the public can then benefit from being able to now exploit this technology that has been disclosed. So the patent expires 20 years from the effective filing date. So it's a limited term for the monopoly. And the overall cost of going through this process could easily be 50,000 or more. And it also depends on the number of countries that applications are filed in. So the cost is significant for each patent application. Next slide, please. So inventorship is a very important concept. It's different than authorship. So it's a legal determination that's based on the facts in the case law. It's determined by the claims of the patent on a claim-by-claim basis. So during prosecution, the inventorship can change if the claims change. Sometimes there's something called a restriction requirement where perhaps the patent office says the method is a different invention than the system. So the system claims are pursued, but perhaps an inventor contributed to the method claim, but not a system claim. So by restricting out the method claims, the inventorship would change for that application. So it's on a claim-by-claim basis. Inventorship requires contribution to the conception of the claimed invention that's not insignificant in quantity when measured against the dimension of the full invention. And it requires more than a mere contribution of a well-known concept or the current state of the art. So it does require something inventive. Merely assisting in the development of the invention or being on a team or supervising the team does not necessarily make a person an inventor. It gets back to conception and what was contributed to the invention. Next slide. So Gen AI is becoming a very important topic now. In 2023, Cornell Research and Innovation issued a report on best practices and considerations for the use of Gen AI. And part of that touches on inventorship. So the report emphasized that documentation of human contribution and disclosure of the nature of Gen AI utilization are essential. And certain key information needs to be carefully documented. So specific Gen AI tools used, the rationale for the use, detailed input by each inventor or team member, and detailed output of the Gen AI tool responsive to each input, and document inventive contributions by each inventor. So going forward, documentation becomes more and more important as these tools are being used, because it is inevitable that both the patent office and the courts are going to be examining inventorship very carefully. And these are issues that will come up. Next slide, please. Another very important consideration is public disclosure can jeopardize or compromise patent rights. In the United States, there is a 1-year grace period from a public disclosure. So we can still file a patent application within 1 year. However, a public disclosure effectively prevents filing of a patent application in the rest of the world, because the rest of the world has something called absolute novelty, where once something is publicly disclosed, it is now in the public domain. You are not allowed to file a patent application. So it's critical for the researchers and CTL to have, for CTL to be informed of new technology before it is disclosed, because it can seriously affect the IP rights that we would be able to look at. So what is a public disclosure? Publication of a manuscript, preprint postings, archive, bioarchive, etc., published abstracts, open thesis defense, because it's open to the public, posters or talks, speaker engagements, social media postings, commercial use or sale or offer for sale. So anything that is a non-controlled disclosure, where a member of the public might be or might be able to access it, that would be a public disclosure. Disclosures under non-disclosure agreements would not be a public disclosure. So that is one way to selectively disclose information for various purposes. Next slide, please. And with that, I will turn it over to Martin. Thank you.
All right, thanks, Bill. Yeah, so as Bill's last slide just said, when in doubt, contact CTL, right? So how do you? So this is really how it starts. Your engagement with our office as a scientist, researcher. But of course, even before that, even before you think you've made an invention, you're always encouraged to reach out to any of our team members. When you start the process with an invention that you think you've made a valuable invention, you would start by submitting an invention disclosure to our office. And just recently, I guess with a few years delay here, we've moved to the modern times and just recently rolled out an online disclosure form. Previously, we still relied on PDF documents and forms that do need a signature. So I guess there's some reasons why we hang on to them for quite some time. But so now we have an online disclosure form that you can access through our website, where you select the type of intellectual property that you think you want to disclose to us. Next slide. The process for technology commercialization is really kind of a cycle where it's really an ongoing iterative review process and process of discussing with the inventors and the market. And so this sort of illustrates, it all starts with research and ideation, folks working in the lab, and then until you have made a discovery of sorts, you will then engage with us through an invention disclosure. We then look at it together with the inventors, the scientists, to understand how that discovery could be protected and how that intellectual property could then really be leveraged for commercialization activity where that could attract funding for the future work that inevitably would have to go into turning the science into products, right? And if all of that goes well, then the university would be able to generate revenue from its licensing arrangements with companies, and that revenue can then be reinvested at the university for more research. Next slide. So we talk a lot about intellectual property and patents, but why do we really care about patents? We're not, of course, filing patents. Bill has pointed out the cost of patents in particular. It may be the strongest form of intellectual property protection, but it's also rather expensive. So we don't just do it for the sake of establishing that the inventors were the first ones to discover something. It's really, what's important is we want to figure out, can an invention be protected such that it actually protects future potential products that would be enabled by that invention or discovery. So we really look through not the lens of not only is it patentable or protectable in some way, but how can that then be turned into commercialization activity, and is there a market? Is there a new market that the invention would have to establish, or is there an existing market that the invention could be leveraged in? Next slide. So as we work with the inventors and industry to assess an invention, we ask many different questions, some related to what the technology is itself and whether or not it's patentable or otherwise protectable. And then, as I mentioned, if it's protectable, how can that IP protection be leveraged in the marketplace? How can a company, a future licensee of Cornell's, take advantage of that intellectual property protection such that it can shield itself or have a competitive advantage over other players in the market? Things that come into play here also is whether an invention, whether a patent can actually be policed. Could you even identify whether a competitor might be using your invention without permission, right? So that's not always easy, depending on what the type of invention, what the types of products are. We look at what else is out there in the market, in the relevant market. Are there competing solutions, and what sort of advantages or distinguishing features does your technology have that could be leveraged? Other questions might be around, are we looking at maybe an incremental but perhaps important and really economically advantageous improvement of an existing product, or are we looking at a new platform that can enable lots of future products or services? Next slide. Yeah, when we look at the market, we ask questions about what is the product, right? What would the business model be based on the invention? Who is the ultimate customer? Who would actually pay for what? I mean, so trying to get an understanding of what the value chain might look like in the particular product, in a particular market. And depending on that, there are oftentimes many factors that are ancillary, that are really not in your control necessarily, and that don't necessarily have to do with your invention or discovery, but they're important things to consider as you want to turn your invention into a product. And then, yes, certainly we look at who are the commercial partners in the area and in the market that we're looking at, and how can we connect or partner with them to further your technology. Next slide. Other factors we consider when deciding to invest in an asset, in a patent perhaps, or a commercialization activity, are also the development status, as others have mentioned before. The inventions coming out of the university lab, sort of by definition, are just very early. So the development status is sometimes people ask for technology readiness level. I don't know if people have heard that term, TRL. And so if you want to put it into those metrics, certainly most of the inventions coming out of the university labs are TRL 2, maybe 3 if we're lucky, right? So it's they're just early, and there's not a lot more investment and development that needs to go into most of them before they can see the marketplace. And then we work with the inventors trying to understand what does that path look like? What would the manufacturing of products look like? And what other components are needed to make this really work? Regulatory pathways is particularly important consideration in the medical space, of course. And then also what sorts of additional data would be needed to support a strong intellectual property strategy, and then to really entice commercialization partners in industry. And how could we get there? How could we help the inventors to obtain that additional data? Linda mentioned before, some of the gap funding might come into play here, where we can hopefully help further de-risk the technology and advance its development status. Next slide. Of course, we don't have all the answers to these questions, and oftentimes the inventors may not have a full understanding of the market dynamics, etc. as well. So we try to leverage as much of feedback and information from the marketplace as possible. We do that by reaching out to companies. We market technologies to industry, to startups, entrepreneurs, investors, to see how we can really get traction. We do that through many different platforms and domains, and overall, it all comes down to we constantly out there networking and try to make connections with the right folks that can help us with these questions. We do also work with interns in our office through the CTL practicum, as Linda mentioned. Currently, unfortunately, with the financial austerity on campus, there's less of that happening, but we're still doing our best to use as many free resources as possible as well. I don't think I'm going to go into more detail here. There's one more slide, I believe. Oh, yes. So, of course, for you as researchers, as inventors, I want to emphasize that your role in this entire process is very important and really critical. It's not just your role in as we write patent applications and as we argue with the patent examiners to get your patent through the examination process. It's also your role as an inventor is also very critical in as we reach out to companies and try to make connections. Next slide. We also want to highlight, so we do office hours for people who might want to check in where they're not sure, they have certain questions, maybe before you even consider submitting an invention disclosure to us. So Boris, team members from our business development licensing group, as well as IP group, are doing virtual office hours. I think we've also recently had our finance team is offering office hours as well. And I believe we're circulating the slides later so people can find out more about it. That's it, I think, from our side. Yes, this is our contact information. Not too much time left for questions, but maybe people want to.
And feel free to raise your hand or to put your question in the chat. We'll be more than happy to answer any question you have about any of the program or information we provide today to you. It's a lot of information, but it's recorded, so we'll be posting online. We'll have the slide that will be shared with you, but don't be shy if you have any question. And the most important aspect is for you, as Martin mentioned, for you to engage with us and to contact if you have any question about the IP. If you are ready to disclose, a BD and licensing officer, they are the right people to start the conversation with. Join an office hour. If you are not available during those office hours, feel free to send an email. They will respond to you right away.
All right. No live questions? Oh, there is one.
Okay. Chris, do you want to go through with the question? If you are available.
Sure.
Or if not, okay.
I can address the first one if you'd like me to. Question was, how accurate does the disclosure need to be? I'm going to rephrase it. I think you mean how complete does it need to be? I mean, it certainly should be accurate, but I wouldn't worry too much about completeness. We will always ask questions. So I think, and yes, it can be updated. I mean, the form perhaps only if there is some incorrect information or maybe incomplete information on the form, then it would need to be updated. But most of the time there's supporting information that we need, in particular when we talk about patents. There's almost always a need for us to get more information from the inventors. Okay, and the slides, we will email them out to the registered attendees, right?
Correct.
There's a question about how long does it take to usually take to hear back? I would say it depends, right? So in particular, when we are talking about a potential patent, as Bill has pointed out, publications or public disclosures kind of trigger the clock ticking, right? So and we certainly want to get ahead of those things. If we see that the invention has sufficiently detailed information included already. So in those situations, whether we like it or not, sometimes we have to act very quickly, right? Because we want to get ahead of the public disclosure. But in situations where there's not that much of a time crunch, I mean, I'd say generally it's a week or two until we would get back to people and at least start asking some questions. I don't know if others want to add to this.
Yeah, I can just, maybe I'll comment also, Martin. I think, it depends on, the response is pretty quick to notify you who will be assigned to review your case and talk with you. That's probably within a few days, if not quicker. And as Martin said, there's often a back and forth that, we have questions, we want to talk to you, see some of the data. How long does it take to make a final decision of whether we're accepting something into our portfolio or not? Depends on kind of how quick that dialogue is able to happen and we get the information that we need. But I think we aim to try to make a final decision within, 2 to 3 months of a disclosure coming in, of the next steps on that, unless there's an imminent public disclosure that we have concerns about, and then we accelerate that. And then I see there's a question about the Catalyst Fund. So that really is funding into Cornell research laboratories. If there is an ongoing collaboration, that might be a discussion to be had. But I'll just point out that the Ignite program, the Ignite Acceleration Program, is for Ithaca researchers. So that's probably a more appropriate one to apply for if you're a Cornell Ithaca researcher.
Thank you, Lisa. Okay, well, it's 1:02. I think perhaps that means that we should bring our program to a close. Thank you everyone for coming. We will upload this video to our website shortly, and I will email out those slides shortly. If you have any questions, feel free to email us. You see all of the contact information still live on your screen. Thank you again for coming, and we look forward to hearing from you in the future. Okay.
Thank you, everybody.
Thank you.
Thanks, everyone.
Bye.
Thank you.
Bye.